Hello, and welcome to Williams Mullen Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Amber Duncan, and today I'll be joined by my colleague, Rob Van Arnam, a partner and chair of our IP section here at Williams Mullen, and also co-chair of the firm's Data Protection and Cybersecurity Practice Group, to discuss an advertising and promotion topic, data protection and privacy of consumer data, a California update. Rob focuses his practice on licensing and litigation of IP rights and also counsels clients regarding privacy, data protection, promotion, and consumer laws. Hey, Rob, how are you doing today?
I'm good, Amber. Good to see you.
Yeah, good to see you. It's good to have the opportunity to talk again about another important topic of data protection and legislation in this area. A hot topic. So let's jump right in, as I know there's been a lot of developments when it comes to data rights. First, what is the state of data breaches generally?
Right. Well, a good place to start. And unfortunately, there are a lot of issues and increases in data breach and vulnerability. Without question, the accumulation of data and new forms of technology and new methods of hacks or attacks are creating new challenges for companies, whether that is mobile banking or services and client interfaces from digital commerce. During this past year, the remote workforce and how employees are connecting with work and their work systems and increased vulnerabilities. And then we've seen a lot of increases in ransomware attacks. Some of those have been a lot in the press lately. And then even down to the sort of day-to-day attacks, phishing, and there's a new one called smishing, which is SMS or phishing attacks sent via text. And unfortunately, employees and folks are even more apt to click on them and open them. So a lot of challenges.
Wow, really sounds like those challenges are increasing. So turning to the specific focus of today's podcast, what law governs customer privacy and data protection in California, and who must comply?
Right. So it's a harder question to answer than it sounds, but for now, it is the California Consumer Privacy Act, or CCPA. And that went into effect January 1st, 2020, and it actually will sunset in January 2023. And the rules implementing it only went into effect this summer. The key there is who must comply, and it's not just companies in California, but it is profit or for-profit entities that both collect and process personal information of California residents, either doing business in the state of California with a physical presence or outside and gathering that data. It's geared towards larger companies. So another requirement for scope is annual gross revenue in excess of $25 million, that they receive or share personal information of more than 50,000 California residents, and 50% of the revenue is by selling personal information of California residents. Those sound like harder targets to meet, but it actually sweeps in a large number of companies.
So what are the general provisions of the CCPA and what does it protect?
Yeah, the CCPA gives consumers sort of new rights and ability to manage their data. It's really the right to know or transparency about how their data is being used, a right to access and a right to opt out of having their data sold to other third parties. And really in sum, it's sort of businesses have to inform consumers about categories of information that will be collected and the purpose for which it's being collected at or before the point it's being taken. And if the consumer agrees to the data collection, they have then additional rights following up. If they want to access or make a request for their personal information to find out more detail about what is being held, and also a right to have it deleted with certain exceptions. Another important point, if consumers exercise any of their rights, a company can't retaliate them. They can't say, well, you need to pay us to exercise these rights, or we're going to increase your service fee for some reason. A couple other key provisions to note. There's a broad definition of personal information. The standards and more sensitive things like social security number or driver's license number, of course, are included, but also unique personal identifiers, such as things involved with online tracking or biometrics. It requires companies to have a more specific and robust privacy policy. So if they haven't updated it in a while, it's probably not in compliance. And the sale of personal information sounds like a direct transaction for money, but it's broader than that. And it can be a simple transfer as long as there's some consideration that the company receives. A couple other kind of key provision is opt out. So there needs to be an easy, simple, and straightforward process to opt out of having their personal information transferred or sold to a third party. And there's certain opt-in requirements for consumers who are basically for kids, for consumers under 16 and with parental consent under 13.
Now, I understand that the CCPA went into effect January 2020, but that it was only recently that we had guidance on what the rules actually require. Can you explain?
Yeah, and that was the difficulty. So even though it went into effect over a year ago, the rules implementing it by the Attorney General were only recent. And there were a lot of amendments, changes, and proposals that happened between January and essentially August of 2020 that people were waiting for. And until that time, nobody knew exactly how to comply. I want to highlight a few items there that either changed or people were hoping would change and didn't. The first is the evolution of service providers. So the definition of a service provider is really important. Service providers provide protection for certain necessary limited transfers of personal information. And so one of the key things is to know, if you're not a data controller, are you a service provider under CCPA, and what are the obligations? The final regulations expanded on the entities and activities that fall under that rubric. So it's important to know sort of where you stand and what that means. The second was the opt-out button. Everybody had hoped that CCPA and the Attorney General would adopt one single button and standard that everybody could use that would be compliant. It would have to say this, it would have to look like this, et cetera. And that just didn't happen. In the first set of modifications, the Attorney General added that, but in the final regulations, they did not. So we are adopting a general standard that folks have put in place, but that was something that did not manifest in the final rule. Also, definitions. One of the notable exclusions from the final regulations was the deletion of a provision clarifying when information maintained by a business is personal information, because that's a pretty broad definition. And unfortunately, there were a lot of attempts to narrow that or clarify it that didn't happen. And then finally, privacy controls. Although modified in some respects, the Attorney General consistently included a requirement to treat user-enabled privacy controls, such as a browser plugin or privacy setting, as a valid request to opt out. So there are maybe less obvious opt-out options and requests that can be made that people need to pay attention to.
Oh, thanks, Rob. Lots to digest there. So now that companies were just starting to understand their obligations under CCPA, I understand there's a new California law to consider. What's that? What are the highlights?
Right. Yeah, that's correct. And unfortunately, just as we were getting used to CCPA, California law has changed again. In November, also by referendum, California passed the California Privacy Rights Act, or CPRA, and that will be effective January 1st, 2023. That's why I said CCPA will sunset at that time, and new regulations will be introduced by July 2022. So unfortunately, we'll have to sort of go through this again. There are some consistencies with the CCPA, but some significant differences. And again, it means that we all need to pay attention to see what California's ultimate rule will be. So highlighting some differences, the Attorney General, and there's a new California privacy authority that will govern the law and enforce it. It creates a new category of personal information called sensitive personal information. There'll be additional rights and obligations for those. There also are new consumer rights, additional right to correct inaccurate personal information, right to opt out of certain advertising, particularly that using precise geolocation of, where exactly you are heading their servers from. It also expands the private right of action. So we do think that there will be more litigation in this front after CPRA goes into effect. It also extends opt-out to certain types of behavioral advertising, as I mentioned. And unfortunately, one of the things, too, at least proposed so far, is removing a 30-day cure period, which was allowed under the CCPA, which would essentially allow a company to try to cure any defect. And finally, another important feature is the definition of contractors' personal information made available to those third parties for business requirements only or business reasons only. And again, it's important for companies to know where they fit and are they meeting that definition.
Well, we're out of time, but I wonder if you could provide our listeners with a summary of takeaways from California privacy laws.
Sure. So first, there's a broad definition of personal information, or PII. Always think about analytics or geolocation. It's not just someone's social security number, it's broader than that. The second thing is to investigate and map the personal information that a company collects and where it's stored, because from now on, you're going to need to know what you have and the ability to get rid of it. Third, privacy policies need to be updated, and you have to allow for opt-out mechanisms. Most companies will need a "Do not sell my information" button in the privacy policy and on their website page. Vendor agreements should be carefully scrutinized. For vendors and contractors, you need to know your rights and obligations. And for those hiring them, you need to make sure that those third parties are living up to your obligations under these laws. And then, of course, while waiting for CPRA to go into effect, you need to comply with CCPA. So it's not a wait and see. That law is in effect now. And just finally, of course, we've been talking about California today, but there are a lot of new state laws. One very recent is the Virginia privacy law. That's the Virginia Consumer Data Protection Act. And that has a lot of similarities to California. So even if a company might not meet the definitions or have to comply with California, it shouldn't dismiss its obligations under other potential state laws like Virginia.
Thanks so much, Rob. That'll wrap up our discussion on data protection and privacy of customer data, a California update. I'd like to thank Rob Van Arnam for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening. Until next time.